First case of the morning is Gregory versus Massey. Attorney Gregory, you are the appellant and across that plea. So during your initial time, please address both. We want, of course, to have separate times for that. And then, counsel, when you have your time, obviously, please discuss both as well, your appeal and the rebuttal to Mr. Massey. As you both know, we generally have 15 minutes to present the argument. How long would you like to reserve for rebuttal, counsel?
5.
5, very good. We'll note that 5 minutes. I will be keeping time up here. I will try to let you know when you get to about a minute left in your time if that will happen. The arguments are being recorded. You both know, please stay behind the podium. Please speak in a loud voice so we can hear you. Please introduce yourself for the record when you come up if you would do so. I don't know in this case if we have victims or anyone. Please don't refer to anybody victim by name. Please use initials, anything of that effect, or some other term for it, a child or a victim. When you're brief and ready to proceed, whenever you are.
Great. Thank you, Your Honor. Giovanna Bremke on behalf of Mr. Massey. I presented in my brief, and the court has stated correctly, there is a cross appeal as well. But in my brief, I've presented one assignment of error, manifest weight of the evidence, and that's based on self-defense. So I will go into quite a bit of the facts because obviously it's relevant to the manifest weight argument. But essentially, Mr. Massey and J.H. were neighbors. They had sort of a tumultuous neighborly relationship. J.H. believed that, Mr. Massey believed that J.H.'s brother had broken into his home at one point, and on this day, this incident had occurred. They were sort of both outside, so my client on his porch talking on speakerphone. There was a little bit of interaction before that, but essentially, J.H. says, who are you talking to or whatever, and they have this disagreement, ultimately leading to, and my client testified that J.H. said, essentially, F you, I'll kill your mom, I'll kill your dad, I'll kill your whole family, I'll bury your mom, dig her up and kill her again. That's transcript page 177, where you hear that. That sort of prompted my client to fire what he deems is more or less a warning shot out of a gun, and in that regard, no bullet had struck J.H. or any other individual. However, a neighbor had seen that, neighbor that was parked on the street, or parked nearby, had seen that her vehicle was had a broken window, and it called the police. That's how this came about. However, and the state makes a point, and I won't disagree, that my client testified that he had concealed that gun. He wasn't, supposed to have the gun, and he had hidden the gun. And initially was not truthful to the police about that, but had come around in saying that. To complicate things maybe a little bit more, is in regards to the self-defense, is both of these individuals have some disabilities. J.H. having a neurological disability, and my client being wheelchair bound. So there was some discussion about how, although J.H. has a neurological disability, he's much stronger than my client, who would be in a weaker position being wheelchair bound, and that led to his fearfulness as well, combined with these prior incidents that he believed J.H. was violent. So I do go through the factors that Mr. Massey, my client, was not at fault in creating this situation. He had no duty to retreat. He's certainly on his property, on his porch. And he believed to be in imminent fear for his life. Again, hearing what J.H. had said, combined with his disability and being fearful that he wouldn't be able to defend himself. The state presents a cross appeal as that the court failed to impose prison terms on the two most serious firearm specifications, and our response to that is pretty much that there was no objection. There was some dialogue, I think it's transcript page 294, but no overt objection. And the state didn't argue plain error, so I think there's case law that this court repeatedly cites to that if the state doesn't, that you won't make the argument for that. So we would ask that you reverse on our brief and affirm as to the state's brief. I would reserve the rest of it.
Thank you.
Good morning, Your Honors. Lindsay Pavlaki for the state. At the conclusion of his trial, the jury was instructed to consider Gregory Massey's claim of self-defense. The jury ultimately returned its verdict, finding Massey guilty of all 6 counts of the indictment, specifically finding that Massey did not act in self-defense with regard to count 1 and count 3 of the indictment, which each carried 3-year firearm specifications. On appeal, this court should likewise reject Massey's claim of self-defense under a manifest weight of the evidence review. As this court is well aware, the state has the burden of disproving a defendant's claim of self-defense beyond a reasonable doubt. After carrying its burden, the state need only disprove one of the elements of self-defense beyond a reasonable doubt. Massey's claim of self-defense essentially rested on his own self-serving testimony at trial. I'd like to highlight some of Massey's testimony from the state's perspective, and as counsel highlighted, there was a verbal argument that ensued between Massey and the victim, JH in this case, while Massey was on his porch and the victim was some distance away in the street. Massey claimed at one point, and he testified, that during the argument while JH was still in the street, that JH began verbally threatening to kill him and his family. In response, Massey, who is wheelchair bound, testified that he went into his house, grabbed a firearm from his bed, then returned to the porch where he placed the gun in his lap, and as the verbal argument continued, he began banging the firearm onto the lift of his wheelchair. Massey testified that as he and JH continued to argue, JH reached around the back of his bike that he was on and appeared to make a movement as if he was reaching. So he lit off the gun. Massey testified that he didn't know what JH had behind his back, but that he never saw him produce a weapon. Massey ultimately conceded in his testimony that when initially questioned by the police, he denied the allegations altogether that he had fired a weapon, and that there had only been a verbal argument between he and JH. In fact, Officer Mitchell testified for the state that during her interactions with Massey, he never mentioned being in fear, nor anyone charging or coming at him. Officer Mitchell further testified for the state that Massey told her that he only had a verbal argument with JH, and that was all it was. On appeal, Massey's claims to self-defense are twofold. Massey claims that he was not at fault and that JH started the argument with him. Second, he claims that he had a bona fide belief that he was in imminent danger, and that because that JH was reaching and threatening him, he was fearful. This court need not determine who is at fault or who started the argument, because the record does not support that Massey had a necessary objective or subjective belief that he was in imminent fear or danger of great bodily harm. In his merit brief to this court, Massey made a very brief attempt to support his claim that JH was reaching, which made him nervous because he is wheelchair bound. But courts have held that words or fear alone is not reasonably sufficient to provoke the use of deadly force in most situations. Massey's claim that he was nervous or fearful simply does not equate to a belief that he was in imminent or immediate danger of death or great bodily harm. The second element of self-defense also requires that the degree of force is warranted under the circumstances and proportionate to the perceived threat. Here, Massey testified that only verbal threats by JH were made before he chose to go into his home, retrieve a firearm, return to his porch, and re-engage the argument. Massey testified that as the verbal argument between he and JH continued, he picked the gun up from his lap. He started banging it on the lift to his wheelchair. Ultimately, JH was on a bike a distance away from Massey in the street. The two engaged in a verbal argument. JH was not armed. Massey escalated the situation by retrieving a firearm and banging it under the wheelchair and firing it. Massey's decision to shoot at JH was disproportionate to the threat he faced under the circumstances. And while Massey was free to argue self-defense and argue that he was justified in using deadly force, the trial court instructed the jury accordingly. The jury reasonably chose to reject his argument and could have easily found that his statements to police on the night of the shooting, where he failed to claim self-defense, were more credible than his trial testimony. Based on that record, this court should determine that the jury did not clearly lose its way by concluding that Massey did not act in self-defense and overrule Massey's sole assignment of error. Now, while Massey's convictions must be affirmed, the state has cross-appealed and submits that the trial court sentence with regard to the firearm specifications is contrary to law. And while Massey claims that the state did not preserve this error for review, at sentencing, the state explicitly requested prior to the imposition of sentence that the trial court impose prison terms for the two most serious specifications and stack them as required pursuant to the statute, the relevant statute on this section, and order them to be served consecutively. It specifically cited Bolar and asked that these specifications be stacked. The court is well aware of the authority on this area of law as it is recently affirmed a state's appeal in State v. Fleckenstein and State v. Ross, and this court has been consistent in holding that 292914b1g requires the trial court to order consecutive service of a defendant's specifications under the conditions set forth in that statute. Because Massey was convicted of 2 or more felonies carrying firearm specifications, and one of those felonies, which was felonious assault, is a felony listed in that statute, the trial court was required to impose a prison term for each of the 2 most serious firearm specifications, which were 3-year firearm specs. It should be noted that in his brief, Massey does not offer any substantive opposition to the state's arguments. Thank you.
Thank you, Drew.
I don't have anything to add.
No thoughts?
Yep.
All right, very good. Well, I thank you both for your presentation today on behalf of the court. The court will take the matter under advisement and issue a decision in due course. That decision will be made by the court and will be available in the High Supreme Court website.